laptop and logged in. So hey ho, we're ready to go, and we're only 10 minutes late.
Awesome.
My sincere apologies to everyone.
Do not worry about that. Do not worry about that. All right, if everyone is ready to begin, I'll open the court. Oh yay, oh yay, oh yay. The Supreme Court of the United States is now in session. The Honorable Chief Justice Hall presiding. All those having cause to be before this honorable court, draw nigh and pay heed. God save the United States, and God save this honorable court.
Thank you to the clerk. Good day to all. We have one case in front of us today on the docket. That is William Denoff, petitioner, versus the state of Olympus. Respondent is the petitioners. Are the petitioners ready? And Hannah, I did not hear you, counsel. I'm sorry, I don't hear you. I feel your pain.
Are you able to hear me now?
We hear you fine. Thank you. So are the petitioners ready?
The petitioners are ready, Your Honor.
Very good. Respondents, are you ready?
Respondents are ready, Your Honor.
Very good. Let's proceed. Thank you.
Mr. Chief Justice Hall, Honorable Associate Justices, and may it please the court. My name is Hannah Kavanaugh. My co-counsel, Allie Satterfield, and I represent Mr. William Denoff, the petitioner in the case at bar. At this time, I would like to reserve 3 minutes for rebuttal. My co-counsel will be addressing the issue of the Eighth Amendment, but first I will be addressing the Fifth Amendment issue. It is our contention that Mr. Denoff's Fifth Amendment right against self-incrimination was violated during the administration of the functional brain mapping exam, or FBME, for two main reasons. First, because Mr. Denoff meets the three-pronged test that this court established in United States v. Hubble. Second, the police officer's neglect to read Mr. Denoff's Miranda rights constitutes a clear Fifth Amendment violation. The first issue that petitioner would ask the court to consider today is a three-pronged test as written in United States v. Hubble, which is as follows. Quote, to qualify for the Fifth Amendment privilege, a communication must be testimonial, incriminating, and compelled, end quote. Thus, in order for Mr. Denoff to be protected, all three prongs of this test must be met. Both the petitioner and respondent agree that the information obtained was incriminating, as page 11, paragraph 3 of the fact pattern indicates. So the only remaining questions before you today are of the following two prongs. As to the first, Schmer versus California clearly delineates how this test is testimonial in nature. While this case dealt with a physical test, procuring a blood sample to determine the blood alcohol level of petitioner Schmerber, the majority noted that, quote, to compel a person to submit to testing in which an effort will be made to determine his guilt or innocence on the basis of physiological responses, whether willed or not, is to evoke the spirit and history of the Fifth Amendment, end quote. This clearly applies to the case at bar, in which Mr. Denoff's physiological responses are being used, despite his clear statement that he wished to give nothing further. With that being said, we can now see how physical and physiological are clearly different in the eyes of this court, but how do we know this test is inherently testimonial? This court set a clear definition in Doe versus United States, holding that testimonial communications are all that, quote, relate a factual assertion or disclose information. This definition applies to both verbal and nonverbal conduct. Nonverbal conduct contains a testimonial component whenever the conduct reflects the actor's communication of his thoughts to another, end quote. In the instant case, Mr. Denoff clearly relayed a factual assertion nonverbally, as the electrical responses he communicated from his brain proved that he was lying about having never seen room 417 at Sleep Suites Motel. The way that this court has distinguished between real versus testimonial evidence is the degree to which that test invades upon the contents of one's mind. The relevant test based on Doe versus United States is not how much information a piece of evidence may provide, but whether or not that information relies on the consciousness of the suspect and the operations of his mind. This very clearly relies on his consciousness of the facts and the operations of his mind, which differentiates it from previous tests that the court has addressed, such as voice and handwriting exemplars, where it does not rely on their consciousness of the facts, but rather relies on physical realities. whereas the functional brain mapping exam cannot function unless Mr. Denolf has memory of being at the scene of the crime. Since this court's jurisprudence clearly points towards the testimonial nature of this test and the information it delivered, the last issue in this regard that the petitioner would ask the court to consider today is the third and final prong of this test, that being whether or not the petitioner was compelled to reveal this incriminating information in a testimonial act. In order for someone to make an informed decision, they must know of all possible options in a given scenario, and the absence of proper Miranda safeguards denied Mr. Denolf the knowledge he needed to make a fully informed and consensual decision to submit to the FBME. The Supreme Court wrote in Maness versus Myers, as cited in Estelle versus Smith, quote, "A layman may not be aware of the precise scope, the nuances, and the boundaries of his Fifth Amendment privilege," end quote. Due to this fact, the Supreme Court held in Miranda versus Arizona that it's the duty of the state to inform them of this privilege. This court went on to write in Johnson v. Zerbs, as cited in Estelle versus Smith, that the waiver of constitutional rights, quote, "must not only be voluntary, it must also constitute a knowing and intelligent relinquishment or abandonment of a known right or privilege," end quote. To determine whether or not Mr. Denolf knew of these rights or whether there was valid consent present, we can turn to Miranda versus Arizona, as cited in Estelle versus Smith. Miranda prescribes 3 things that must be read to an individual whenever they are in an inherently coercive environment. However, the state contends that the environment he was in was not coercive. But this court disagreed in Pennsylvania versus Muniz. In that case, when Muniz was in the booking center and being asked questions that were directed at gaining testimony, he was determined to be compelled because they had moved him from the non-compelling environment of the roadside test into the compelling environment of the police station. The same parallel is seen in the instant case, where Mr. Denolf is removed from the non-compelling environment of his home and taken to the compelling environment of a government-contracted testing facility. Since this environment was inherently compelling pursuant to Muniz, he needed to be informed of 3 key options available to him. The first is the right to an attorney. The second, the right to remain silent. And the third, that anything he says could and would be used against him in a court of law. While the petitioner submits that pursuant to the fact pattern, the first 2 were at least hinted at, if not directly informed to him at various points in the investigation. But that third and final prong, that being whether or not his words could or would be used against him, was never hinted at nor directly mentioned at any point in the investigation. Since officers never informed Mr. Denolf of this key aspect of Miranda, he cannot have been said to have knowingly and intelligently have relinquished his constitutional privileges in the eyes of this court, because we don't even know if he knew about them in the first place. Supreme Court case United States versus Avery, as cited in Pennsylvania versus Muniz, only further emphasizes the compelling nature of Mr. Denolf's environment and saying, quote, "Without obtaining a waiver of the suspect's Miranda rights, the police may not ask questions, even during booking, that are designed to elicit incriminatory admissions," end quote. This case holds that during booking, after arrest, or otherwise, police may not ask questions designed to incriminate without prior warning. The Fifth Amendment was clearly violated because the petitioner did not have what Miranda versus Arizona, as cited in Estelle versus Smith and several other cases in our packet, summarizes as, quote, "an intelligent decision as the exercise of his rights," end quote, in the setting of the FBME. His freedom of action was significantly curtailed. Petitioner did not know of the options available to him. After examining the clear precedent set by this court throughout history and the agreement of both parties, it's clear that all 3 prongs of this test must be met. Mr. Denolf was compelled. He communicated his memory through a testimonial act, and the information obtained was incriminating because it relied on his consciousness of the facts, and he didn't know of his options. Mr. Denolf's Fifth Amendment rights were violated in the process. Absolutely.
If I may ask a question, considering the FBME test does not directly extract testimonial communication, but infers it based on physiological responses, how do you equate the nature of this test with conventional means of testimonial self-incrimination, given that the data obtained is arguably indirect, passive, and nonverbal?
Absolutely, Your Honor. And while I do understand that it does differentiate between previous types of testimony, such as someone taking the stand and speaking to us, it doesn't change the fact that it is testimony pursuant to this court's ruling in Doe versus United States, where they talk about implicit communication and nonverbal conduct even. So long as this conduct that Mr. Denolf is exhibiting does incriminate him, does have that testimonial capacity present, it is a testimonial act. This conduct relied on his consciousness of the facts, as it was. Your Honor, I see that my time is about to expire. Chief Justice Hall, may I briefly conclude?
Please do.
Thank you so much, Chief Justice Hall. And it's because the precedent set in this court clearly delineates one fact, that Mr. Denolf was compelled, and the second fact, that this was a testimonial act. The petitioner would respectfully request that the ruling of the 12th Circuit Court of Appeals be overturned.
Thank you.
We would like to ask that any observers in the room please observe through the NCFCA live platform and not in the room directly. Thank you so much.
Permission to proceed, Your Honor?
Please do.
Thank you. Mr. Chief Justice, Honorable Associate Justices, may it please the court. My name is Allie Satterfield, and I, along with my co-counsel, Hannah Kavanaugh, represent the petitioner, Mr. William Denolf, in the case at bar. Today, I'm specifically going to be addressing the violation of his Eighth Amendment rights. There was an egregious violation that occurred when he was sentenced to a 30-year stint in solitary confinement because that goes against the evolving standards of decency that ought to mark the progress of our maturing society. And furthermore, Poseidon Penitentiary has deliberately disregarded and willfully ignored pressing threats to Mr. Denolf's health and welfare. And it is for this reason that we ask this court to overturn the lower court's decision. In Trop versus Dulles, this court clarified the scope of the Eighth Amendment, stating that while, yes, it is undefined and fluid, the basic concept surrounding it centers around the dignity of man, and that it draws its meaning from the evolving standards of decency that mark the progress of a maturing society. In that particular case, Mr. Trop had his citizenship stripped away from him pursuant to a clause in the 1940 Nationality Act because he briefly deserted from the United States Armed Forces. And this court deemed that to be unconstitutional under the Eighth Amendment, even though they deemed that it was a penologically justified act under the 1940 Nationality Act. They claimed that because it was still cruel and went against how society would view cruelty at the time, that made it unconstitutional. Thus, even if you today believe that there are penological justifications for Mr. Denolf's punishment, that does not mean that there was not an Eighth Amendment violation pursuant to how this court ruled in Trop versus Dulles. In Rhodes versus Chapman, this court clarified the scope of conditions of confinement, stating that they must not involve the wanton and unnecessary infliction of pain. And Justice O'Connor, in writing for the majority in Hudson versus McMillan, wrote that pain in its ordinary meaning surely includes a notion of psychological harm. Thus, if you believe that Mr. Denolf is suffering a wanton and unnecessary infliction of psychological pain due to his punishment, then a decision to overturn the lower court's decision is warranted. Lehman versus Hegelmo, as is cited in Rhodes versus Chapman, clarified this idea further, stating that in determining when prison conditions pass beyond legitimate punishment and become cruel and unusual, the touchstone is the effect upon the imprisoned, and that if the cumulative impact of the conditions of incarceration threaten the physical, mental, emotional health and well-being of an inmate, and or increase the probability of recidivism, this court must conclude that those conditions violate the Eighth Amendment.
Question. Olympus reserves sentence of solitary confinement for the most violent of criminals. Would you agree that your client falls into this category?
I would say that according to the judge's ruling, yes, he deemed that Mr. Danoff was a very violent offender, and he used the justification that he tortured his victim to sentence him to solitary confinement. However, the rationale that because Mr. Danoff is a violent offender and should be sentenced to solitary because he might pose some threat of future potential danger is invalid. And we can see this by turning our attention to Estelle versus Smith, in which this court had the American Psychiatric Association Task Force on the Clinical Aspects of the Violent Individual testify that the psychiatric community are of the opinion that clinical predictions as to whether a person would or would not commit violent acts in the future are of fundamentally very low reliability, and that even psychiatrists possess no special qualifications to make such predictions. Thus, even you, Your Honor, believe that Mr. Danoff might pose a potential danger. That prediction is irrelevant according to the psychiatric community. And even if you find that line of argumentation to be unpersuasive, we would contend that we are not facially challenging solitary confinement as a whole. If Mr. Danoff is seen to be a threat at any future point, he could have been placed in disciplinary housing for administrative reasons. According to page 6 of the facts of the record in footnote 5, Olympus actually has 6 different levels of restrictive housing. And the level that Mr. Danoff was placed into was that of solitary confinement. The judge preemptively sentenced him to that particular level of restricted housing to serve for the duration of his stint in prison. And that is what we are contending is unconstitutional.
And counsel, let me just rewind a bit. You preface your whole argument about the advancement of society, which leads me to believe we're dealing with more legislative issues and not court issues.
No, Your Honor, we are dealing with an issue of constitutionality today, because if we examine the scope of Eighth Amendment issues in the past, whether it be Trott versus Dulles or Thompson versus Oklahoma, that was this court examining the legislatures that states had and the bills or laws that they had put into place and whether or not those were constitutional or unconstitutional. This court does possess the authority to overturn such legislation, granting that judge that authority if it deems it necessary to do so. And we would contend that it is because of the cruel nature of solitary confinement. In Helling versus McKinney, this court set forth a 2-pronged standard consisting of both an objective and a subjective harm that must be proven to deem a punishment cruel. And that objective harm has to consist of a scientific and statistical inquiry into the likelihood and severity of a potential harm and proof that society is unwilling to accept it. In Porter versus Clark, experts were testified as stating that there has been not a single published study of solitary confinement that was non-voluntary, lasting longer than 10 days, in which individuals did not develop negative psychological effects. Even in this court in In re Medley, as is cited in Porter versus Clark, we recognize that a solitary confinement led to inmates becoming violently insane, falling into semi-fatuous conditions, and committing suicide. Page 20 of the fact pattern indicates that although solitary confinement inmates comprise only 6 to 8% of the prison population, they account for half of all suicides.
So counsel, you mentioned the word cruel, and I have to think, and I'd love for you to balance for me, putting a violent offender in general population, is that not cruel to those in general population? How is that balance to be tested?
Certainly, Your Honor. Well, once again, if Mr. Danoff was placed in general population and was shown to be a danger to other inmates or prison staff, he could be placed in solitary confinement as a last resort. We are simply contending that solitary confinement's use as a punishment for crimes committed prior to entering the prison system is what is cruel. And if you are genuinely concerned about Mr. Danoff's likelihood to harm other inmates, we are not contending that he couldn't have been put to death. The facts of the record indicate that the judge was indeed able to sentence him to death, and that would be permissible pursuant to this court's ruling in Gregg versus Georgia. But as Trott versus Dulles held, the existence of the death penalty is not a license for the government to devise any punishment short of death within the limits of its imagination. So just because he could have been sentenced to death, that doesn't mean that solitary confinement is any less cruel. And it is because it is a cruel punishment we ask this court to overturn the lower court's decision.
Mr. Chief Justice, may I proceed?
Please do. Thank you.
Mr. Chief Justice Hall, Honorable Associate Justices, and may it please the court. My name is Claire Say, and I represent the respondent, the state of Olympus, on the Fifth Amendment issue. My client has acted within the constitutional limits of their authority to investigate and prosecute terrible criminals. Consequently, we would ask this court to affirm the lower court's ruling. Because the use of the functional brain mapping exam, or FBME, in the case of Mr. Denolf was neither testimonial nor compelled, we would ask this court to uphold the ruling of the lower court. The Minnesotan Supreme Court in the case of Minnesota versus Diamond summarized this court's test of Fifth Amendment analysis, its three-pronged test that this court established in the case of Fisher versus United States, writing that, quote, the privilege against self-incrimination bars the state from 1, compelling a defendant, 2, to make a testimonial communication to the state, 3, that is incriminating, end quote. While we would concede that the information obtained through the FBME in the case at bar is indeed incriminating, we would contend that because petitioner's claim must meet all 3 of these prongs, and that the petitioner's claim fails both of the last 2 prongs of this test, that this court laid out in Fisher, again, we would ask this court to affirm the lower court's ruling. Regarding the issue of compulsion, opposing counsel largely summarized or clarified their interpretation of this court's jurisprudence on the issue as revolving around the issue of Mr. Denolf's transfer between locations, namely from his home to a police station. And they compared this to the situation of the Pennsylvania versus Muniz, in which the defendant in that case was transferred from a roadside sobriety test to the booking center. However, never in this court's history has it ever made a distinction between a transfer of location. Rather, the particular distinction this court has always made is whether or not an individual is in custody. And precisely, it is only when an individual is in custody is when this court has ruled that there are those inherently compelled pressures because of their custodial nature of the interrogations or the test defendants are undergoing in that case. Particularly in the case of Roberts versus United States in 1980, as cited in Justice Rehnquist's concurring opinion in Stell versus Smith, the requirement to Mirandize, namely inform them of their Miranda rights, a suspect, quote, does not apply outside the context of the inherently coercive custodial interrogations for which it was designed, end quote. Mr. Denolf is precisely not in custody. Page 5, paragraph 1 of the record explicitly notes that at the beginning of Mr. Denolf's interactions with law enforcement, he was specifically warned that he was free to leave or stop speaking or stop cooperating with the police at any time. And page 5, paragraph 3 of the record notes that at the beginning or after the introduction of the FBME test to Mr. Denolf, he explicitly said that he was not comfortable answering any more questions and wouldn't say anything more. Mr. Denolf clearly understood those previous warnings to carry over to his participation in the FBME. He absolutely voluntarily participated in the functional brain mapping exam, and thus no Fifth Amendment violation occurred. Again, simply because a defendant is transferred locations doesn't mean that Miranda warnings are required to be read to a suspect. It's rather the booking center in the process of arrest that is the constitutionally significant part, something that isn't present in the case at bar, despite the fact that it was present in the case of Pennsylvania versus Muniz and other cases in the record. Regarding the issue of testimoniality. Yes, Your Honor.
So, counsel, you preface this with the what's at stake is, or what's discussed is the transfer from home to police. Does the same police station, does the same argument hold true in the transfer from the police station to the testing station?
Your Honor, simply what I'm contending is that it is not constitutionally significant whatsoever where Mr. Denolf is. The only significant part is whether or not he is in custody. That's the only distinction this court has ever made. The reason there was significant difference between the roadside sobriety test and being in the booking center in the case of Muniz that opposing counsel brought up is because the defendant was brought to the booking center to be arrested, and he was in the process of being arrested. So the court cases and the jurisprudence opposing counsel brought up was all regarding after a defendant has been booked in the process of being arrested, questions that defendants are asked, thus they must be Mirandized before they are asked such questions or subjected to interrogation or tests of any kind. Regarding the case at bar, again, he's not in custody. He was free to leave or stop speaking at any time. He understood those privileges to refer to his participation in the FBME, and he clearly felt free to assert those privileges as well. Regarding opposing counsel's arguments regarding the testimoniality of the test, their interpretation of this court's jurisprudence again revolved, I believe, largely around one phrase, namely the contents of the mind. They noted that the question was whether or not there was a factual assertion or disclosure of information. And while this court has used that phrase, I think it's crucial to note that this court only used that phrase in the context of a communication, an act of communication of the
Question: if the test reveals whether one does or does not have a memory of a particular image or event, doesn't a memory qualify as the contents of one's mind?
Your Honor, I would simply say that this court, in light of advancing technologies, has actually moved away from the phrase the contents of the mind. For a long time, and leading up through Schmerber versus California, this court largely used two pretty clear categories for Fifth Amendment testimonial analysis: purely physical tests, namely a blood sample, a vocal exemplar, or even something like a fingerprint, and then a second category of anything that implicated the contents of the defendant's mind. But then in the 1966 case of Schmerber versus California, this court was faced with something like a polygraph test. And there the court said, for situations like that, and opposing counsel roughly mentioned this, but there this court said that when physiological responses are paired with verbal interrogation, our old categories are no longer viable. So this court had to come up with something different. And that's exactly what they did in the case of Doe versus United States, where they ruled that, quote, in the Schmerber line of cases, the court distinguished between the suspects being compelled himself to serve as evidence and the suspects being compelled to disclose or communicate information or facts that might serve as or lead to incriminating evidence, end quote. Fundamentally, the distinction is...
If I may ask a question.
Yes.
Do you believe that a new standard of consideration should be developed in light of emerging technologies such as the FBME and how it relates to the Fifth Amendment in its relation to the case at hand?
Respectfully, Your Honor, I think it already has been developed through Doe and onto this court's ruling in the case of United States versus Hubble. Fundamentally, the question, because we have advancing technology like a polygraph test, where it's both physical and implicates the contents of the defendant's mind, we have a difficult situation. And what the court's distinction in Doe and onto Hubble was, has there been an act of disclosure or communication from the defendant that is compelled? Not simply is information, incriminating information, being conveyed to law enforcement. Because if that is our standard, something like the slurred speech of the defendant in the case of Pennsylvania versus Muniz might hypothetically implicate the contents of the defendant's mind, and it would fundamentally hamper law enforcement investigations. So in light of advancing technology, this court determined, is it the defendant himself serving as evidence, or is the defendant being required to act to communicate information? In the United States versus Hubble, this court actually reaffirmed that interpretation, noting that, quote, there is a significant difference between the use of compulsion to extort communications from a defendant and compelling a person to engage in conduct that may be incriminating. Goes on to rule that, quote, the act of exhibiting physical characteristics is not the same as a sworn communication by a witness that relates either express or implied assertions of fact or belief, end quote. There must be an act by the defendant that communicates this information.
If I may ask an additional question. As we've established, the petitioner stopped answering questions and kind of cooperating per se with the police when he was taken to, although he was following, into the testing room, but he again refused to speak, and could it be assumed that he was actually attempting to not cooperate but could not understand fully the extent in which this test would affect him or his mind, or which kind of content would be taken out of it, and he was actually attempting not to be helpful, I guess, but it was without his consent retrieved from his mind?
Absolutely, Your Honor. And there, I think a couple things in the record are very instructive. First, it notes that the doctors or the technicians explain the FBME to Mr. Denolf. The record is silent as to their particular explanation, however, I think it's a reasonable inference from the record to infer that they communicated the broad contours of the test. he was going to be shown images, and his brain's response was going to be recorded. However, the record notes that it goes on to say that they informed him that the FBME was purely procedural, much like drawing blood or taking fingerprints. There, I think their comparison to drawing blood or taking fingerprints is helpful due to the fact that drawing blood or taking fingerprints are commonly understood activities that could tie an individual to the scene of a crime. They're tests exhibiting physical characteristics that have the very real potentiality of being incriminating. And it looks like
Counsel,
my timer's about to expire.
And I'm going to ask one question and permit you to answer it. You yourself, counsel, have stated multiple times that FBME gave a response to a prompt. And it feels to me the definition of a question is a prompt and a response. And so directly after Mr. Denoff said, I'm not going to answer any more questions, you're prompting and giving responses. Yes?
Roughly, Your Honor, but I don't think in the constitutionally significant sense of the term. So first, regarding a little bit of the issue of Mr. Denoff's instructions regarding the test. It was explained to him, at least the rough contours, his brain was going to be examined, he was going to be shown images, and this was potentially incriminating. In light of that, he clearly understood that he was free to leave or stop speaking at any time, a privilege that he did assert at the time. But despite their communication or rough explanation of the test to Mr. Denoff, and if this court would like more information, it can always remand for an evidentiary hearing. Paragraph 4 goes on to note that Mr. Denoff did not resist the FBME and was cooperative throughout the duration of the process. He did not simply not show hesitation, he was actively cooperative throughout the duration of the process, despite, again, his knowledge of his privileges. Regarding your question about the similar functional equivalent of the question, this court has established a similar doctrine in terms of witnesses in the context of a police interrogation in custody, which isn't applicable in the case at bar. However, I think there's a crucial fundamental difference. There is no active production in the case at bar. How this court determined how we ought to answer the question is there a constitutionally significant active disclosure required from the defendant? This court actually revived their 1964 decision of Murphy v. Waterfront Commission of New York Harbor, namely has a cruel trilemma of forcing the defendant to choose between perjury, self-accusation, or contempt of court been imposed. Mr. Denoff has no option to perjure himself. It's simply an implicit physical response to an image rather than a choice to verbally respond to a question, which this court has repeatedly confirmed is a constitutionally significant difference. Mr. Denoff was not compelled. The evidence is not testimonial. Thank you.
Thank you.
Permission to proceed, Mr. Chief Justice Hall.
Please.
Thank you. Mr. Chief Justice Hall, Honorable Associate Justices, and may it please the court. My name is Caleb Brown, and I rise to continue to represent the respondent, the state of Olympus, on the Eighth Amendment issue. The state of Olympus has acted within exacting constitutional limits of their authority to impose punishment on the worst criminals in our society. In today's case, a man who not only murdered but tortured his victim. Consequently, we would ask that this court affirm the lower court's ruling. The Court of Appeals for the Fourth Circuit noted in 2019 in Porter v. Clark that the controlling case for determining the threshold a petitioner must meet is this court's 1994 decision in Farmer v. Brennan. In Farmer, this court reaffirmed the standard it formulated in 1990 in Wilson v. Sider, as cited in Hudson v. McMillan and Helling v. McKinney. In all four of this court's decisions, it noted that the threshold a petitioner must meet to satisfy an Eighth Amendment challenge contains two prongs. There's first an objective prong, asking whether or not a given punishment is recognized by society as being reasonable. And secondarily, there is this subjective prong, asking whether or not prison officials acted with deliberate indifference to an inmate's basic needs. We will address each of these prongs in turn. First, looking at the issue of the objective prong, this court described it in Farmer v. Brennan as a deprivation that was, quote, objectively or sufficiently serious, in court. And specifically, this court noted in Hudson v. McMillan and Estelle v. Gamble that the objective component, quote, is therefore contextual and responsive to contemporary standards of decency, end quote. As Chief Justice Hall pointed out earlier in the questioning of opposing counsel, the central issue for determining the issue of the objective component of this Farmer test is the legislative prerogative of the states. And although opposing counsel is correct that in some situations this court may intervene, ultimately the only way that this court is capable of determining whether Trott v. Dola's analysis is correct, namely whether society has actually evolved, is at looking at the actions of different state legislatures. This was confirmed by this court in Helling v. McKinney. Writing there in 1993 for the majority of that court, Justice White made clear that, quote, also with respect to the objective factor, determining whether McKinney's conditions of confinement violate the Eighth Amendment requires more than a scientific and statistical inquiry into the seriousness of the potential harm and the likelihood of the injury to health. It also requires a court to assess whether society considers the risk that the prisoner complains of to be so grave that it violates contemporary standards of decency. Quote. In short, Your Honor, we would argue that the only way to satisfy the issue of the objector prong isn't necessarily the issue of a penological justification, although they may be important and persuasive to this court. It is, in fact, a comparative analysis of the states. Even opposing counsel correctly identified that Trott versus Dulles itself notes that the only way that we can determine that the dignity of man has been affronted by a punishment is through the evolving standards of decency, which are articulated by societal opinion on the particular issue. Thus, Your Honor, we would point to several key data metrics from the record that indicate that society, we would argue, hasn't actually shifted in favor of opposing counsel's position. Rather, it remains unified with the state of Olympus. The first data metric, Your Honor, comes from the record on page 7, noting specifically that at least 40 different states, as well as the federal government, still use some form of solitary confinement. Secondarily, Your Honor, even though the record does speak of the issue about states shifting away from solitary confinement since the 1990s, there's about 20 different states that do so, the record continues to note that only 3 of those states have actually fully banned solitary confinement, meaning that even those states still allow it to be used in some particular cases. But even if we assume that the generic application of solitary confinement isn't sufficient to show a societal consensus, we would turn this court's attention to one last data metric that we believe is perhaps the most persuasive in the entire record. It is found on page 15, paragraph 1 of the lower court's opinion. It's in the very last paragraphs of the lower court's majority opinion specifically. And they note there that if we look at the exact type of solitary confinement that Mr. Danoff is housed in, a supermax prison, which Poseidon Penitentiary is indeed one of those, this is actually used not just by a handful of states, but since the 1990s, 44 different states, as well as the federal government. Thus, Your Honor, even if we look at the generic application of solitary confinement, or if we look at what I believe is the more persuasive issue of the exact type of supermax facility that Mr. Danoff is housed in, I would argue that not only is the state of Olympus consistent with the societal evolving standards of decency, but the society is actually running as fast as it can to the state of Olympus's position. Thus, Your Honor, we would argue that opposing counsel does not satisfy this first issue of the objective prong. Now, opposing counsel did cite several different citations from this court's jurisprudence to support this position. For instance, they noted that a penological justification in and of itself does not necessarily satisfy or comport with Trott versus Dulles' evolving standards of decency test. And although this is true to an extent, I would disagree in some part. For instance, the particular penological justification cited by this state, Mr. Judge Fair, the sentencing and trial judge, was that we would argue of retribution. This court has actually noted that the concept of retribution still does comport with the dignity of man. For instance, in Gregg versus Georgia, which did concern the issue of the ultimate punishment, the death penalty, they noted on page 184 of that decision that, quote, retribution is no longer the dominant objective of the criminal law, but neither is it a forbidden objective, nor one inconsistent with a respect for the dignity of man, end quote. Thus, Your Honor, we would argue that the particular legislative choice by the state of Olympus is one that this court has recognized as being acceptable. It comports with the dignity of man, and thus we would argue that what this court noted in Gregg versus Georgia still holds true, that ultimately this court should be cautious in making an Eighth Amendment judgment, and more importantly, that we generally default back to the legislature to allow them to make their own individual statements. There, Justice Stewart, writing for the plurality in that case, noted that, quote, therefore, in assessing a punishment selected by a democratically elected legislature against the constitutional measure, we presume its validity, and a heavy burden rests on those who would attack the judgment of the representatives of the people, end quote. Your Honor, before moving on to the issue of the subjective prong, I would like to address one last different citation opposing counsel referenced. Specifically, they noted that in Porter versus Clark, there was a wide variety of academic literature that noted the different harms, or even the future harms in some cases, of solitary confinement. But what I think is perhaps most intriguing about the case of Porter versus Clark, even as it is our most recent case available to us in the record, is what is found on page 362 of that decision. Because the court in Porter versus Clark, the Fourth Circuit Court of Appeals, issued a very caveated ruling in that case. They did not note that solitary confinement per se would be unconstitutional, nor limited to someone of Mr. Danoff's condition, or perhaps even in the case of a supermax facility. Rather, they noted that they only ruled for the petitioner on Virginia death row in that case, because the state of Virginia advanced absolutely no penological justification during argument before that court. What they noted, however, was that if indeed the state had advanced a penological justification, it could support, in the terms of that court, quote, indefinite detention, end quote. Thus, we would argue that even the jurisprudence citing by opposing counsel, the most recent available to us in the record, still indicates that the evolving standards of decency have evolved in favor of the state of Olympus. Thus, Your Honor, we would choose to move on to the second prong of the Farmer test, which asks whether there is a subjective component. In effect, has there been deliberate indifference on the part of the state, either the sentencing judge or the prison officials at Poseidon as it relates to Mr. Denolf's conditions or sentencing? We would argue, and if we look at both of these, that this has not been the case. However, I would like to point out at the outset that even if this court completely agrees with everything that opposing counsel has discussed thus far about the sentencing authority to judges, or perhaps his lack of medical care, or the conditions of Poseidon Penitentiary, that does not intrinsically satisfy an Eighth Amendment violation. Because what this court recognized there in Farmer versus Brennan, as subsided in Porter versus Clark, is that negligence alone does not rise to the level of an Eighth Amendment challenge. Quote, deliberate indifference is far more than mere negligence, but less than acts or omissions done for the very purpose of causing harm, or with knowledge that harm will result, end quote. In short, Your Honor, simply showing that there are perhaps undesirable conditions of Poseidon Penitentiary, or even perhaps a lack of
Let me
medical
ask
care.
a question. Recognizing the high prevalence of psychological disorders among inmates in solitary confinement, can the state provide a compelling argument to justify solitary confinement as a necessary punishment rather than a form of cruel and unusual punishment, given the potentially severe and long-term mental health consequences?
Your Honor, I would say two things. First, Your Honor, I would say that the primary reason that the state submits before this court today is the same one that Justice Fair issued at the trial sentence, namely that he has tortured his victim, which speaks to the penological goal of retribution. As this court noted in Gregg versus Georgia, such an analysis, such a particular penological justification as retribution, is one that actually still comports with the dignity of man and is viewed as acceptable by this court. Secondarily, though, Your Honor, you speak to the issue of the future harm as it relates to Mr. Denolf. We would argue here that nowhere in the case of the prison officials nor the sentencing judge was there any deliberate indifference to that harm. As far as the prison officials are concerned, they specifically would argue, even though maybe perhaps show negligence, do not have a culpable state of mind. Nowhere in the record does it say that they specifically knew of an issue related to someone of Mr. Denolf's character or situation that indicated that there would be harm. The closest the record comes to is describing how there's a 75% chance of recidivism upon release, but even that statistic is not specific to just the single cell units of Poseidon. As far as the judge is concerned, Your Honor, we would point that it's important detail on the record that the judge actually ordered an evaluation of Mr. Denolf's mental health care, and Mr. Denolf did not present the crucially mitigating factor of a previous disposition. Thus, we would argue the failure is on Mr. Denolf, and this court should affirm. Thank you.
Do I have permission to proceed, Chief Justice Hall?
You do. And to the clerk, let's add 1 extra minute, please, since we gave some extra time to the opposing counsel, please.
Very well. Mr. Chief Justice, Honorable Associate Justices, the petitioner wishes to offer 2 lines of argumentation in this rebuttal. First, in regards to the Fifth Amendment, that Mr. Denolf was indeed compelled. Now, here's why I wish to clarify that Pennsylvania versus Muniz did indeed address how the booking center was coercive and the roadside test was not. However, Muniz goes on to further clarify that Miranda does apply outside of custody as well by stating that, quote, when the physical nature of tests begins to reveal testimonial or communicative statements, the protections afforded by Miranda are invoked, end quote. Additionally, United States versus Avery stated the same. So opposing counsel's assertion that the court has never held that claim or made such a claim is false. Additionally, opposing counsel's reliance on Roberts versus United States was a case that was held in 1980, whereas Pennsylvania versus Muniz was held in 1990. Thus, it is the controlling case in this courtroom today. Furthermore, the information gleaned by the FBME was testimonial. If Doe is in fact the new standard, which is the standard that my co-counsel referenced throughout her argumentation, the Doe standard explains exactly what this court meant by testimonial or a testimonial act by stating that it is conduct, verbal or nonverbal, that requires the accused consciousness of the facts. This, as Justice Dean pointed out in her questioning of opposing counsel, requires the consciousness of Mr. Denoff's facts. When he was examining those images, he had to be conscious of the fact that he was in that room for his synapses to fire, meaning that it is testimonial pursuant to the standard that both the petitioner and respondent have agreed we should use, that being of Doe versus United States. Now, the second line of argumentation we would offer today is in regards to the Eighth Amendment, that indeed Mr. Denoff's sentence meets the standard posed by opposing counsel, that being the standard from Farmer versus Brennan. It is objectively harmful. Now, opposing counsel contended that society is willing to accept solitary confinement. However, this is simply not true. In fact, as opposing counsel mentioned, since 1998, 20 states have moved away from utilizing solitary confinement by adopting laws limiting or banning its use. Additionally, 7 states previously did not allow for solitary confinement, and no state since 1998 has adopted laws increasing the use of solitary confinement. Now, opposing counsel referenced supermax prisons and how solitary confinement is used throughout the nation, and we would once again contend we are not facially challenging solitary confinement, but rather the manner in which Mr. Denoff was sentenced, that being by a judge for a crime he committed prior to entering the prison system. No other jurisdiction outside of Olympus allows individuals to be sentenced in this manner. And because states have gradually shifted away from using solitary confinement, we can see that this is indeed how society is evolving. But secondarily, Poseidon Penitentiary was deliberately indifferent, and we can see 4 key areas in which they were. First, there were underqualified mental health professionals on site. Secondarily, there was no oversight for said mental health professionals. Third, there was no inpatient psychiatric treatment available for prisoners suffering from mental health harms due to their confinement. And fourth and finally, there was no mental health pre-screening for inmates prior to receiving their sentence. While we do recognize that it is not constitutional for inmates to have unqualified access to health care, prison officials cannot be deliberately indifferent to the severity of harms that solitary confinement poses. That's why we'd ask you to overturn.
Thank you to all counsel.
The Honorable Court is now adjourned. Congratulations. Good job, guys.
Yes,
Thank
great job to you all as well.
Thank you. Good job.
Good job.
Thank
Have a
you.
good evening.
Thank you. You too.
Thank you.